Good morning, Your Honors. Please report. My name is Stanley Lipsky. I represent Jackie Desmond, who is the appellant in this case.
You're gonna reserve 5, sir?
I'm sorry,
You're gonna reserve 5 for rebuttal?
3 minutes.
3 minutes, okay, thank you.
I don't even think I'll get to that,
Okay.
but we'll figure it out. We're here on a re-entered amended final judgment from the lower court. Basically, the issues, the case started out as Mr. Jesmer suing his sister because she was a personal representative of the estate of the father dealing with a Honduran asset, which was a residence there. Based upon that, there was a motion for summary judgment that was filed there was a pending motion to dismiss. We went to the summary judgment hearing, and at that point in time, the court, in its judgment, basically decided this case not on the issue of a summary judgment, but basically stated that he's going to rule on the motion to dismiss and state that he does not have subject matter jurisdiction because the asset is in Honduras, and he did not have personal jurisdiction over Janet Jesmer, who in this case was a resident of Hillsborough County and she was sued initially in Pinellas County and transferred from Pinellas to Hillsborough County. In that, the Honduras estate is open and was administered by Ms. Jesmer. She received according to what we have of a translation that my client had to translate, the will and the record from Honduras gave her a 50% interest in the estate. My client, who was also and beneficiary based upon the will, he was to receive 50%. He received nothing. Ms. Jesmer administered the estate unbeknownst to my client and obtained her 50%. We then got the transcripts of the will and of the proceedings and obtained the information of the transfer to her of the 50%. In the case before the court indicated it did not have subject matter jurisdiction over the Honduran asset. We don't necessarily take issue with that because that is an asset in Honduras. However, where my client takes issue is that Janet Jesmer, who never filed a motion and never filed a pleading attacking personal jurisdiction, was ruled upon on a motion to dismiss that went outside of the summary judgment hearing that we were having. And the judge basically said, I don't have jurisdiction over either one of them.
With that, because when I read the judge's order and I've read the record in this case, I didn't see a ruling on personal jurisdiction. I only saw a ruling on subject matter jurisdiction. If you could focus me on where that is, that would be very helpful.
The reason of judgment on the second page, for the reasons above, this court has no jurisdiction over the Honduran real estate, nor any jurisdiction over Janet Jesmer, as it relates to an order or judgment affecting title to or real estate property in Honduras.
Well, as it relates to the Honduran judgment, is what I read that to read.
As it relates to judgment affecting title.
Yeah.
Now, we cited to the court the Singer case, in the Bouchel case, and I filed a notice of supplemental authority of the Shin case from the Supreme Court. The Singer case is the first DCA, the Bouchel case is the Supreme Court case, and the Shin case is a more recent Supreme Court case. In that Shin case, which specifically stated, and it was a May 26, 2022 opinion. It has long been established that a court which has obtained impersonal jurisdiction over a defendant may order the defendant to act on property that is outside of the court's jurisdiction, provided that the court does not directly affect the title to the property while it remains in the foreign jurisdiction. Although a court may not directly act upon real or personal property which lies beyond its borders, it may indirectly act on property by its assertion of impersonal jurisdiction over the defendant. That's exactly what the issue is here. Did the court have impersonal jurisdiction over Janet Jesmer to ensure that she administered the estate as the personal representative for the benefit of both of the parties in the will.
And I
And
think
that would be
that's
Mr.
the
Gesner as
complication
well
in
as
this
Mr.
case, Mr. Lipsy, is that there was a foreign probate proceeding underway. The I think it's Shim, the Shim, the Shim case that you're relying upon deals only with the notion of property out there to which there is no probate proceeding attached. Here we have a foreign jurisdiction that has accepted presumably jurisdiction over all of the assets in Honduras and is adjudicating it. Can you address that complication for me? Because I didn't see that argument.
Well,
really.
Ms. Gesner is a resident of the state.
I get it. I get that you really want this to be a personal jurisdiction argument. I'm bringing it back to subject matter jurisdiction just for a moment. Can you address the issue that a circuit court in Florida could wrest subject matter jurisdiction from a Honduran court that is in the process of or was administering the very same asset in its probate proceeding? That's troubling to me, and I need you to address that for me.
This court in the United States does not have the authority to order any other court or forced jurisdiction, be it Honduras or any other state, that says you have to do this.
Okay.
You have to put property in the name of both parties pursuant to the will. However, that brings us to the other cases that are cited, and the Shim case as well as the Shim case as well as the Chinga case, as the Bushell case, and they all stand for the proposition you can't order a foreign jurisdiction to transfer title. However, you do have the authority to order somebody in under your jurisdiction to comply with what is the requirements of here, and that would be, as she stated in her affidavit in support of her amended affidavit of Janet Gesner, and it's dated October 31st, 2018 or 19. And it basically says at the bottom, I do not control the Honduran residents. No. The Roytan property is being administered by the probate court in Honduras. Of course, this was all unbeknownst to my client. It says the Royton property will be distributed according to the laws of the Royton probate court. It is my understanding that after payment of the expenses for probate maintenance of the house, the property will then be distributed to myself and Jack Gesner on 50-50 basis. So she admits that that's the way the property is to be distributed. The issue is that all she's done now is she has taken a half of an administration and says, give me my 50%, albeit I'm the personal representative, and I have a responsibility as the PR to administer the estate pursuant to the will, but we're not going to give my brother any of that, in hopes that he's not able to come to Honduras, in hopes that, whatever the deal is, he's being cut out. And we discovered this based upon obtaining a copy of the will finally, after the proceedings have already begun, and after she's already gotten the property transferred to her. And after all that is over with, and the court's, it's open. So is she transferring it? Does the court have the authority to say, do what you say you're going to do in your affidavit, that's what it is 50-50, as well as what the will says? Then we probate that foreign will, if you will, even though it's a probate, even though the property is in Honduras. Can you do an ancillary probate in Hillsborough County or in Pinellas County where he done to enforce the will? Because the will says 50-50. There's no question about what the will says, and she even admits it. So we're here today saying we have a lawsuit pending that says we're entitled to the 50%. You need to give us that 50%, and you need to give us an accounting, basically, of what you've done with all the other assets that were all part of that probate. So do we have personal jurisdiction? Yes, we have personal jurisdiction. Does this court have personal jurisdiction over her to order her to, as the Shinga case stated, obliged to ensure that legal title to property situated in a foreign country is properly vested in persons entitled to receive the property under the law of the foreign jurisdiction. Well, the law of the foreign jurisdiction is the same law as ours, which he admits, and the will says 50-50. So to convert a motion to summary judgment to a motion to dismiss because you don't have interest on jurisdiction still is the same proposition. If you want to do that, you need to put people on notice. You just don't do it at the final judgment. As stated, although the defendant filed a motion for summary judgment as to the Honduran property, it is more appropriate that the court deem the motion to be a motion to dismiss for lack of subject matter jurisdiction. Subject matter. That motion must be granted. But preceding paragraph says her no jurisdiction over her either.
As it relates to the property in Honduras. I mean, we can go around and around on that.
I mean, it goes full circle, but I mean, what do the ultimate end result is what are we talking about? We're talking about an administration on the state in Honduras, over which this person resides in Hillsborough County, and she is the administrator over there, and according to the Chinga case, to ensure that property is vested accordingly. I mean, it's basic. Thank you.
You'll have 5 minutes when you return. Yes, sir.
Please, the court, counsel. I believe that your honors have correctly interpreted the order that is under review here. The order granting motion for summary judgment. This was argued pursuant to a motion for summary judgment. There is a parenthetical comment in it, as you've seen, that Judge Nielsen added, that this could be considered, it's more appropriate that the court deem the motion to be a motion to dismiss for lack of subject matter jurisdiction. This never had anything to do with personal jurisdiction. It's subject matter jurisdiction that is as different from personal jurisdiction as anything can be. So the court did consider it under the proper theory, and throughout these proceedings, in every answer, I think this was based on a third amended complaint, so there have been 4 complaints. Throughout, there's been an affirmative defense stating that there's no subject matter jurisdiction, and there was a motion, brief motion, saying there's no subject matter jurisdiction, and sole issue in the motion for summary judgment was that as well.
So what is the son's remedy?
The son's
Because
remedy,
I mean, he's been knocked out of court here on subject matter jurisdiction on an estate that appears to be improperly probated in Honduras, because only 50% of the property came to your client. The other 50% of the property, I guess, is just in limbo.
that estate is ongoing, and if you look at the affidavit in support of the motion for summary judgment, it specifically states that. And by the way, of course, there is an affidavit in support of the motion for summary judgment. There is no counter affidavit, nor any listing of any other summary judgment evidence. So that estate is ongoing, and the remedy is for Jack Jesmer to hire an attorney in Honduras to pursue his interests there. There's no reason he can't. It's ongoing. But for him to pursue this here is absurd. If you look at all of the things that are listed in the third amended complaint.
But Mr. Lipsey's point is, your client as the personal representative of the estate did not do her job and basically have the estate distributed and closed because she made no effort to get the son's interests distributed to him.
There is no evidence of that. There's no evidence that Honduras law even has the concept of a personal representative. I don't know if they do or not, but there's no evidence that she is a personal representative anywhere, not in her affidavit, not in any, the argument's been made by counsel, but not in any summary judgment evidence. Is there an indication that she is, quote, a personal representative?
So your position is she just went down to the courts of Honduras and got her interests, and that's all she was required to do.
I'm not familiar with Honduras law.
I will tell you, and just speaking candidly, that just from the briefing and from the arguments that are presented and from what it said, there seems to be an aversion to doing a deep dive into Honduran law in this.
Yes.
And I get it. I totally understand why, but here on review, you're kind of asking us to work with a black box, so to speak. I mean, we've got this issue that, hey, there's this probate court, it's doing this thing to this stuff in Honduras, but no one really knows what that process is. And nobody's unpacking it for us. And what should we do with that?
Well, the reason.
I think you would probably just say affirm. I mean, but I'd like to have a little better feel for that. And
Yeah.
I mean, you're posing some legitimate questions, and I think that they would have been great to have had answered.
Well, sometimes there is a black box, and sometimes the black box is the very rationale for the existence of the theory. I mean, a lot of the cases that I looked at in this subject matter jurisdiction area were even cases where Florida didn't want to interpret or Alabama law. Anyway, the fact that it is not possible for us to understand and fully comprehend and argue and decide Honduras law is why.
Except for it's done all the time. All the time we have foreign law in US courts and we get to the bottom of what the foreign law says. It happens all the time.
Well, here we have Honduras law. It's in Spanish. And
Well, there are a few Spanish speakers here in Tampa, so that shouldn't be a problem.
I'm aware of that, of course, but the law of another country is not.
See, here's what I'm bothered about. Is that the lawsuit was brought against your client because she didn't do her job as personal representative. Your position is, I don't know that she was a personal representative. But isn't that a proper subject of a court here to determine whether she was, whether she wasn't, and whether she did her job?
No, it's not.
This isn't about affecting title to property. It's about the responsibilities that a PR had and determining whether she was or was not the PR.
Well, for one thing, this, of course, this probate down there is ongoing. So they have alleged a lot of things that I don't know how they can be determined. Certainly damages can't be determined until the probate is done. And it makes no sense for the court here to determine whether she is in compliance.
Well, whether it makes sense or not, we do things all the time that don't make any sense because we're required by law to do them. So, you know, I bring you back again to the issue about whether or not a court here has the right to hold your client accountable if she was the personal representative, or to determine whether she was a personal representative. She was a resident of Hillsborough County. You know, so there's no issue that she's here and determining whether she was or wasn't under Honduran law is just not a foreign thing for courts to do. We do it under Sharia law, we do it under German law, we do it under Japanese law, we do this all the time. This is not unusual.
Well, it also under the case law cited, it's not proper. And I bring the court's attention to some of the cases that were cited. The Shim case has a specific limitation. It says it right in the first paragraph that it can only act on foreign property because there's a statute 56.29(6) that authorizes that.
Yes, but that's about affecting title to property. That's not what Mr. Lipsey's been arguing. He's been arguing this court has a right to determine whether your client acted properly in her position as personal representative or whether she was or not. He is not suggesting that this court take a position on the title to the property. That's clearly, you know, properly in the Honduran courts. The question is, did she act appropriately in her role in carrying out her responsibilities, if in fact she had any?
And his proper remedy, as you asked about, is to do that. I've argued several of these issues in the probate courts here in Hillsborough County. In Hillsborough County probates, the proper venue for Jack Jesmer to argue this is in the Honduras probate court. And I note too that one of the other cases that's been cited to you all, the Siomu case, in the third page of it, it's in italics. The court says, go ahead and get this straightened out in Romania, and then do what the Romanian court says to do. And that's what should be done
That
here.
again was affecting title to property.
Well, and this will affect title to property. There is a house.
No, the Honduran court can determine in whose name that property will be titled pursuant to the probate down there. They're not going to determine whether or not your client carried out her fiduciary duties as a personal representative. Again, if in fact she is one,
Well,
that's a totally different matter.
I see, but the probate court will make sure that the matter has been handled properly, and it's certainly much simpler for the probate court in Honduras to do it than for Hillsborough County Court to do it.
Well, again, simplicity is not the issue here.
The doctrine of subject matter jurisdiction, though, is based on every other state or nation having the right to its own governance of its laws and its property. And here it's very clear that the Honduras courts should have that.
What you're describing is more of a principle of comity, not so much as an issue of subject matter jurisdiction. I mean, you are right that there's a level of deference that courts within our jurisdiction are supposed to give to proceedings and judgments and rulings from foreign courts as a matter of comity, but that's a little different than subject matter strictly speaking. And I didn't see that argument ever getting raised, so I don't know what to do with it. But then again, Honduran law really hasn't been presented to anyone, so I'm not sure how comity could be extended in this case.
There is that, certainly. And there is a comment made in the respondent's brief that he shouldn't be required to go to the expense of litigating this in Honduras. It is a matter of whether his expense is not determinative, whether it's more expensive for him here or there. It's another jurisdiction, and they have jurisdiction over their real property. And for that reason, Judge Nielsen was correct that the subject matter jurisdiction does not lie here, and therefore it was correct that he dismissed this or granted the motion for summary judgment on that basis. And by the way, one of the reasons this was brought pursuant to the motion for summary judgment is there was one fact that I had to determine. This could not be done purely as a motion to dismiss, because there is an exception, and it's in my brief. In fact, it's the Throckmorton case from 1878 that talks about you cannot get protection from subject matter jurisdiction if you have hidden the existence of these proceedings from the other party. And that had to be addressed factually, and that's why I did it in a motion for summary judgment. And we alleged it and swore to it in our affidavit. There is no counter affidavit. And by the way, there was a letter. Jack Jesmer knew about the death of his father. They lived together. And there was a letter from opposing counsel a couple months later. And then this lawsuit began just a few more months later. It's not like it was a long period of time before he knew. Certainly he knew. So that's why it was posed as a motion for summary judgment, but it was also posed as a motion to dismiss. And so the court should affirm the ruling granting the summary judgment for subject matter jurisdiction as entered by Judge Nielsen. Thank you, Your Honors.
Thank you. So let's say you have 5 minutes. So
Thank you, Your Honor. I don't believe I'll rebut. I think based upon your all's questions, thank you. I mean, if there's an issue is that you think I should address, I don't feel it necessary to address any of them, other than the last comment of what my client knew but didn't know. And if the court goes to the issue of saying, what did you know? They provided us in discovery after 18 months, the will from the probate, and they provided it in Spanish. They didn't provide it in English. My client personally paid to have it transcribed. And so it is at that point in time, he didn't speak Spanish either, that we find out what's going on. Thank you.
Thank you both. It's certainly an unusual case. Have a good day, gentlemen.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
And that completes our docket. We will adjourn to deliberate these cases. All rise.